vehicle. The state's response is, I'm sorry, Your Honor.
To testify as to his experience with his motorcycle.
Yes, Your Honor.
Happened to be the same make and model.
That's correct. And under 701, we have two requirements to meet. One is that the witness being called rationally perceived the event, and second, that it had some bearing on the material issue at the trial. All three witnesses had experience with this intersection. Mr. Kletzer and Mr. Lindecombe had experience with the bushes, as did Mr. McCartney. Mr. Kletzer was a township trustee. Mr. Lindecombe was a Ohio Department of Transportation employee who had experience with the bushes. Now, that's important because between the time of the accident and the time of the trial, the bushes were removed. So it became important to have the jury see and hear about how those bushes could be an impediment. Now, certainly there were photos, but our view was that we needed that type of testimony. The state's position is that all this doesn't make any difference at all, not one difference at all, because in the state's view, this is a strict liability statute. We agree with that. But strict liability doesn't remove the requirement for the state to prove all the elements of its case. It simply says that under 2901, 21, and 22 of the culpable mental state statutes in Ohio, that the government doesn't have to prove purposely, knowingly, recklessly, or negligently. That doesn't mean that it dispenses with the other elements of proof. So as a result, given those two other elements, approximate result, immediate hazard, the existence of the bushes and the impediment, the obstruction that they created, became very important. And so we thought it was important that we be allowed to introduce that testimony. The nature of the testimony is also important in the sense that once the bushes are removed, the jury has no real perception of how that may have impacted upon the government's proof in the case. So since they're gone, we need to have someone who had actually seen the bushes and could attest to the difficulty one might have coming to the stop bar at that intersection of 604 and 539, of how that may have impeded one's view of an oncoming vehicle from the left. And yes, sir.
Well, when I read the briefs, my immediate thought was your client could have testified to that, but she didn't think the same.
She did not testify. Of course, Your Honor, she has a constitutional right
Absolutely.
not to testify. And I could explain to the court why that was, but that's not in the record. And it's also not in the record. I couldn't do that. So what we think about when we think about abuse of discretion is a very tough standard, a very difficult standard for me to meet. But the predicate for proper exercise of discretion is sound reasoning. We believe in this case we have unsound reasoning, and that is the trial court failed to put together, acknowledge or recognize the nexus between the testimony about the bushes and their possibility of creating an obstruction and the elements that the state had to prove, approximate result and immediate hazard. So we would suggest to the court that the testimony would have been testimony perceived by the three witnesses personally, and it was helpful, the word in 701 is helpful to a determination of a fact and issue, and those being the two facts.
And what was the trial court's rationale for?
The trial court's rationale was that they were not at the accident, and that was evidently a very important matter for the trial court. Our view of 701 is that's not necessary. If they can provide first-hand information of circumstances relevant to the case, and they weren't talking about someone else's report of what may or may not have been there. They were talking about their position when the bushes were there and the obstruction that created. So for those reasons, we believe that the trial court erred. Turning to the second issue, again, is a very difficult issue. Manifest weight arguments are very difficult to present. This court recognized in dicta in a State versus Peasley, a case on which Judge Carr and Judge Moore, you concurred, that there is an exception. You didn't find it there, but there is an exception. When the evidence presented, which is conflicting, is substantial, when the evidence is substantial, overwhelming evidence, then that may be a proper circumstance in which to invoke this court's constitutional power to reverse a jury's verdict under manifest weight. This is the type of case. This is that type of case. There are certain keys in this case, and they deal with the obstruction, they deal with distance, they deal with speed, and they deal with time. I noticed that, I don't know if the court has its brief, but I was going to refer to pages of the brief, pages 3 through 8, and I do have copies, if the court would like that. Of our brief. And these are photos. Do you? Okay, I didn't see it. Thank you. The reason we put those in there is they illustrate what the jurors would have seen. And as sitting, and you'll be sitting as a 13th juror, your obligation, as difficult as that may be, is to look at the evidence, evaluate the evidence, and determine whether the jury lost its way. These photos demonstrate that the jury lost its way. When we think about an obstruction, I'm not actually going to do a science test, but I thought a lot about this. If I have an obstruction close to me, let's assume I want to see that door, and this obstruction is here. For me to see that door, I just have to pop my head around a couple of inches. But as I put that obstruction, the folder, closer to the object, I actually have to move my head farther. Why is that important? It's important because we have two obstructions in this case, as reflected in the exhibits, which are stipulated. We have the house, which is about 40 feet from the stop bar. The house itself is 60 feet wide. We then have a set of bushes that are 7.5 feet wide by 7.5 feet high, closer to the roadway, 8 feet off the roadway. The point is that from a person's viewpoint, from the stop bar to the beginning of those bushes is 110 feet. Why is that important? That is important because from that position, had the motorcycles are historically difficult to see, the motorcycle would have been at the bushes beyond the ken of Ms. Huffman. She could not have known that the motorcycle was there. So the obstruction created by both the house and the bushes becomes extremely relevant. We believe the jury paid inadequate attention to that. When we think about the obstruction, we also have to think about distances. The distance from the stop bar to the bushes is 110 feet. That becomes important when we think about time and speed. Time and speed. The question was in conflict as to what speed Mr. Gray was traveling. Our expert believed that he was traveling at 45 miles per hour. The government's expert believed he was traveling at 29 miles per hour. And that, the government's view, was based upon, unfortunately, where Mr. Gray ended up on the pavement. If he was traveling at 29 miles per hour, he was traveling at 42.5 feet per second, and this is in the record. If he was traveling at 45 miles per hour, he's traveling at 66 feet per second. Why is that important? The distance between the bushes and the point of intersection is 110 feet. What our expert testified to was that our client was traveling at roughly 3 miles per hour. So when you think about that, it's a very slow rate of speed. That's actually about 4.4 feet per second. It's like you would travel in a regular walking pace. So our client was coming into that intersection at a rate of 4.4 feet per second. At 1 second, she was 4.4 feet into the intersection. At that point, if he was traveling at 45 miles per hour, Mr. Gray was 66 feet closer than he had been. At 29 miles per hour, he's 42.5 feet closer. Our expert says it took her about 2 seconds to get to the point of impact, which means that she would have traveled 8.8 feet. During that same time period, that 2-second time period, Mr. Gray would have traveled over 130 feet and just under 90 feet. Our expert also testified to the fact that normal reaction time for the normally abled human is about 1.5 to 3 seconds. He estimates that my client took about 2 seconds to get to the point of impact. If we put all those things together, if we look at the obstruction, if we look at the distance, if we look at the time, if we look at the speed, at the point in time when Ms. Huffman passed the stop bar, she would not have seen the vehicle oncoming, number one. At 1 second, he would have been more than 2/3 of the way to her. If her reaction time was very fast at 1 second, he was on her. And that's the point that we think the jury missed. The jury failed to consider those very close proximities in terms of time, speed, and distance. We're not talking about minutes here. In fact, my client made a statement to Officer Pettit, responding on the scene, that she was sitting at the stop sign for 3 or 4 minutes. Why? Because she couldn't see past the bushes. She said that she looked both ways 3 times, at least 3 times. And then she took off rather slowly at about 3 miles per hour. If you look at the objective facts, I'm not even talking about the conflict between the testimony, the objective facts, obstruction, time, distance, and speed, we're talking about a fraction of a second within which she would have been able to react. Thank you, and I'm done with my argument. I would just ask the court, if the court has any further questions, I'd like to answer them, otherwise I'll reserve the rest of my time. Thank you.
Thank you. Good morning, Your Honors. May it please the court, my name is Olivia Boyer, and I represent the appellee, the state of Ohio, in this matter. And I'd first like to dive into a number of issues that were raised by Mr. Caro in his argument. First and foremost, it was well established in the transcript of the trial record before the jury that the photographs that were referenced by appellant in his brief, they were never authenticated as true and accurate depictions of the intersection as viewed by any party that was at the intersection on the day of this incident. The defendant, as already alluded to by Mr. Caro, did not testify. She did not authenticate them. Trooper Pettit, the initial officer that arrived on scene at the day of the crash, was actually asked on redirect examination if he could authenticate any one of defendant's exhibits 1 through 10 as being a true and accurate depiction of the intersection standing at the stop bar line as he viewed it. And he said that he could not authenticate those as a true and accurate depiction. So I'd ask the court to take that into consideration when viewing the photographs that are included in the appellate's brief.
Well, what happened, did the trial court admit that?
Yes, Your Honor, and that was due to a lack of objection on behalf of the state. And the jury can still consider those and can give them the proper weight, given that no witness authenticated them. So I believe that that's what the jury did, that they gave them the appropriate weight, given that no witness could say that this was the view that was to be considered. Also, Your Honor, I would direct your attention to the cross-examination of Mr. Eselstein, the appellant's expert in this particular case. There was a disagreement as to the speed of the decedent and the speed that the decedent was traveling. Sergeant Thorne, the expert for the state in this particular case, used what's called a serial equation. And there were a number of variables that the expert for the state of Ohio had to establish in order to use that particular equation. And Sergeant Thorne testified that in his experience, that this is the more appropriate equation to use in order to identify or establish what speed a motorcycle or a vehicle is traveling. Mr. Eselstein was asked during the trial, why didn't he use this equation in order to establish the speed? And he said, well, there were a number of variables that I couldn't answer to in order to use that particular equation. But on cross-examination, if you look to page 183 of the transcript, he was cross-examined as to each variable he identified for his reasons for not using that equation. Was asked, well, couldn't you have done this to alleviate that variable? Yes, I could have. Couldn't you have done this? Couldn't you have spoken to this witness? Couldn't you have spoken to the defendant, the appellant? And he admitted that there was more that he could have done in order to use the serial equation, which Sergeant Thorne testified that he believed to be the appropriate and accurate equation in order to determine the speed. Given that type of evidence within the transcript, it's reasonable to think that the jury did not lose its way, but rather they chose which expert to believe, which theory of the case to believe. Also, going back to Mr. Eselstein, there was a number of statements regarding as to where the defendant appellant was able to see and perceive Mr. Gray, the decedent in this particular case. And Mr. Eselstein relies on the defendant appellant's written statement in order to estimate at what point did she perceive the decedent coming on State Route 604 when he was proceeding lawfully. That was never put into issue as to whether or not he was proceeding unlawfully given an excessive speed, reckless operation, or any such issue that would cause him to be proceeding in an unlawful manner. And
what about her statement that he, and I don't recall,
came out of nowhere, flying out of nowhere? That
suggests an excessive speed.
If Ms. Huffman was a more qualified witness to estimate speeds visually, like a certified peace officer in the state of Ohio, maybe, but she couldn't give an estimate as to what the speed was. And both the state's expert as well as the defendant's expert stated that the decedent's speed was appropriate. This was a 45-mile-per-hour speed zone. There was no testimony that his speed was reckless. There was no testimony that it was excessive.
But there was quite a difference in your estimate speed.
Correct, but both were well below or at the speed limit for the area.
That may be, but it does impact the ultimate finding here in regard to the time, the distance, all those factors in regard to the accident itself.
If those factors are determined by this court to be relevant, the appellant had an obligation to yield to a vehicle. And in order to establish that the defendant violated committed a vehicular manslaughter offense, the state has to prove that Mr. Gray, on the date of this offense, was an immediate hazard, and that her failure to yield was the proximate cause of his death. Now, the defense counsel and the state both stipulated to exhibits, states exhibits M and N, the death certificate, as well as the coroner's report that established that Mr. Gray did die as the result of injuries that he sustained in this crash. So we have already established that Mr. Gray died as the result of the traffic accident. So the question then becomes, was he an immediate hazard? And Sergeant Thorne testified at trial that yes, for a number of reasons, Mr. Gray did constitute an immediate hazard. Now, there are a number of cases that are cited to by appellant with regard to what constitutes an immediate hazard, and I would ask that the court take a closer look at one of the, specifically, Your Honor, we're looking at in Ray Neal. Appellant asserts in their reply brief that the Court of Appeals reversed the defendant's conviction because the defendant presented evidence the decedent may have forfeited the intersection by speeding, which suggested the defendant did not violate the under traffic offense. Actually, that's one of a preceding paragraph, but actually what the court says in the third district court case of In Ray Neal is that because the trial court failed to find whether the opposing vehicle possessed the right-of-way, it erred in finding Neal guilty of violating Ohio Revised Code 4511.44, failure to yield, and consequently further erred in finding Neal guilty of vehicular manslaughter. That's not what we have here. The trier of fact in this particular case, the jury, could have determined that the decedent was proceeding in a lawful manner, and that, coupled with Sergeant Thorne's testimony that the decedent constituted an immediate hazard, was sufficient for a conviction. Now, if we look to the 1958 case out of the 7th District, State v. Ray, the condition of the roadway does not alleviate a driver from the obligation to yield. And that is the crux of the appellant's argument, that the bushes blocked her ability to see down the roadway, and therefore she couldn't perceive Mr. Gray. And therefore, because she could not perceive him, she could not yield to him. But if we take that argument and apply it to a number of different scenarios, we're going to fall down the rabbit's hole. That would, if we take that argument to its logical conclusion, then anyone can claim, well, I couldn't see because the corn stalks were too high. I couldn't.
Would that be an issue then?
Yes, Your Honor, but also the appellant's asking to fashion almost a reasonableness standard here.
I understand, but so your viewpoint is, I think what you're advocating is it's never going to be a traffic. It's just going to have a lot of it.
There are circumstances where the opposing vehicle's conduct could contribute to the traffic accident. And that...
but any obstruction, there could never be any situation where obstruction would be reason enough that they're not going to.
In this particular case, the obstruction wasn't sufficient to alleviate, but there are situations where an obstruction could alleviate the defendant from their obligation to yield. And that was actually a case that was cited to by appellant, I believe it was State versus Nicholson, a 12th district case from 1986, where the opposing vehicle was traveling at about 48 to 45 miles per hour, and the vehicle was 500 to 600 feet away and was cresting over a hill, and the truck had already entered the intersection. But what the court determined there, that the defendant's truck had appropriately entered the intersection because the other vehicle did not constitute an immediate hazard. That's different than the case we have here. Mr. Gray was close enough to the intersection, so close as to constitute an immediate hazard. And that's why the failure to yield statute has that necessity of the opposing vehicle being in an immediate hazard. Also, I would ask the court to take a close look at Ms. Huffman's statement. Ms. Huffman states that she initially stops. She acknowledges that she could not see. She doesn't acknowledge what obstructed her view, but she acknowledges that she could not see. So she says that she pulls up to a point where she could see. And that's not the numbers that were cited to by Mr. Carroll. Those are the original calculations by Mr. Eselstein in his report. However, at trial, during cross-examination, Mr. Eselstein assumed that Ms. Huffman only pulled up so far as to the fog line. He did not include in his calculations that Ms. Huffman could have encroached upon the intersection beyond the fog line, thus increasing her line of sight down further to increase her visibility and going past the obstructions. Also, Mr. Eselstein conceded during cross-examination at the trial level that in his graph, in his chart, where he plotted the bushes were closer to the intersection than where Sergeant Thorne had placed them. Now, the appellant has made issue of the removal of the bushes. However, I would argue that that is a subsequent remedial measure, that it need not be taken into consideration by the jury. The jury was provided photographs, state's exhibits that included the bushes as a part of photographs of the intersection, and the jury had a clear and accurate view as to the intersection from the day of this accident and took that into consideration when they deliberated and when they found the defendant guilty of this particular offense. The jury had before it a plethora of evidence. They had before it both Mr. Eselstein's expert report and the state's expert report from Sergeant Thorne when they deliberated and took into consideration all of the theories. They had Ms. Huffman's statement. Ms. Huffman's statement writes in bold cap letters that it was a dangerous intersection. Any testimony from Mr. Klutzman, from Mr. Linderman, from Mr. McCartney would have been repetitive at most. They didn't personally observe the intersection. Yes, they could have testified to the dangerousness of the intersection, but that would have distracted the jury from the ultimate issue as to what happened when Ms. Huffman was operating her vehicle. And as to Mr. McCartney's testimony regarding the sound of the motorcycle, Mr. McCartney never examined the motorcycle that was operated by the deceased Malcolm Gray. He couldn't say what state of repair it was in, what type of sound it was, whether or not it had any muffler conditions. He only had experience with his particular motorcycle. Also, any extrapolation that he would have had regarding the condition of Mr. Gray's motorcycle would have required an expert witness report, and that wasn't provided. In advance, according to Rule 16K, 21 days before trial, in order for him to testify beyond layperson testimony. So under 701, yes, it has to be on his own personal observations, but he didn't observe the bike here in question. Mr. Cluster's testimony, being a Department of Transportation employee, yes, he could have testified as to a lack of visibility, but the jury had photographs of the intersection. They could make that determination themselves. And Mr. Lindemann,
You're saying more or less it's cumulative?
yes, Your Honor, and repetitive, and it would have distracted the jury from the ultimate issue that they had to determine. And it is a very high standard before the court. It's our contention that the jury didn't lose its way. They just merely found Sergeant Thorne's estimations of the speed, his version as to what constituted an immediate hazard for Mr. Gray to be more credible. And if you compare Mr. Eselstein's expert report to Sergeant Thorne actually visited the scene of the crash well in advance of trial. Mr. Eselstein only visited the scene of the crash the morning of the trial. Mr. Eselstein relied on actual Google Maps that are taken, photographs that are taken by a satellite in order to plot his points. Sergeant Thorne took his own measurements, took his own points, and coupled that with Trooper Pettit's measurements and points when compiling his report. And this was all brought out during cross-examination and direct examination in front of the jury during the trial. And using that, the jury having seen that, they could determine which expert they wanted to believe and which theory of this incident that they wanted to believe. And yes, Ms. Huffman does have a Fifth Amendment right not to testify, but the jury considered and reviewed her own written statement that she made the date of the incident. And nowhere in her written statement does she say, I could not see Mr. Gray because of bushes. She does state, I pulled up to where I could see. And you're right. Thank you.
You have just a little less than 2 minutes.
Thank you. May it please the court, I have 4 brief points to raise on rebuttal. Number 1, at page 49 of the September 23 transcript, there was a joint stipulation to the photos. My understanding, unless the law has changed, is that that's an agreement that the exhibits may be produced and admitted before the jury. So I believe that constitutes any waiver of any problem with authentication or any other defects in the exhibits. Second, we're not disputing that there are 2 different speeds that may have been, at which the vehicle may have been perceived, and that is Mr. Gray's motorcycle. And we've looked at both the distances and speed and time for 29 miles per hour, which is Sergeant Thorne, and 45 miles per hour, which is our experts. I would also ask the court to look at page 4 of the brief, and that's a photo of the point of impact. The point of impact shows us that the motorcycle did not hit the vehicle and stay straight onto the vehicle. Rather, the motorcycle turned. So the motorcycle now was, the force of the motorcycle was dissipated and was heading north, number 1. Number 2, there was a dent on the hood of the vehicle, suggesting that the decedent hit the vehicle. There was also a cracked windshield on the passenger side. Some people think that was the airbag being deployed, but it could well have been the decedent hitting the windshield. All of those factors would dissipate the degree of force, calling into question Sergeant Thorne's measurement of 29 miles per hour. Third, the state suggests that Ms. Huffman was not in a position to determine speed. First of all, in City of Oregon versus Jenney, a case not cited in the brief because it wasn't an issue, the Ohio Supreme Court, subsequent to a statutory change, felt that individuals who have experience driving can figure out the speed of an individual. Having said that, we didn't say anything about the speed. We said he came flying out of nowhere, we couldn't see him. What I would also ask the court to consider is that that was a statement that might otherwise be considered an excited utterance. She was under the influence of the excitement. A person had just died or been seriously injured. And I would suggest to the court that it was truthful and honest. And finally, Your Honor, we did not raise an issue of subsequent remedial measure. That was not in our brief. We never talked about that. Thank you, Your Honor. And we'd ask the court to reverse the decision below and order in the trial. Thank you.
Thank you, counsel, for presenting your arguments to the court. The court will take the matter under advisement.